Julia, that might be because I'm not speaking. Hoping everyone can hear me okay now. Good morning, good afternoon, wherever you are. Hello, Keith. Welcome. Thank you very much, all of you, for joining us again for our 9th Fair Farms webinar of 2023. It's great to have you with us today. And given some recent activity, just to give you a little context, there's been a little bit of union activity around our industry, both down south and in Queensland, with the union doing what they do, which is to seek to represent their members and other staff employees working in their industry. So we know they've got a little bit more active of late. And I thought today was a really good opportunity for us to talk a bit more broadly also about worker consultation. So have a bit of a discussion about what we mean. I wrote an article a while back in a couple of the magazines around worker consultation, excuse me, why it's important and how it can help your business run a lot more smoothly. So we're going to kind of start with that concept of worker consultation and talk about some practice. And then I'll go in and talk about union engagement and how you actually manage when the union comes to call. So welcome today, everybody. And as always, the first thing we do is to acknowledge the stories, traditions and living cultures of First Nations people on the lands and waters on which we meet today. We recognise their connection to land and environment and celebrate their care for country for over 60,000 years. We pay our respects to elders past and present and emerging, and we value their skills and knowledge as our first horticulturists. Okay, so as I alluded to, in the part 1, we'll do employee consultation. So we're going to define it. What do we actually mean? In what situations must we consult? So there's some there's several legislative and requirements under the award. Work health and safety consultation, and I want to talk a little bit about work health and safety representatives, and we'll talk about a consultation framework. In part 2, we'll talk about the role, the rights and the responsibilities of unions, the right of entry rules and all of the documentation that's required. And then we'll just have a little conversation about engagement and conduct when working with unions on your work site. Okay, let's kick off. So consultation, as you already know, but it's worth repeating, is a two-way process where you talk with your workers about matters or issues, and particularly anything in relation to change. You listen to their concerns, you raise your concerns, you seek and share information and views, and you consider what your workers say before you make decisions. So any situation in which the Fair Work Ombudsman becomes involved, that's going to be the standard. Did you have meaningful consultation before you made a final decision? And as I said, it's especially important when you're introducing major change that can affect those workers. Now, consultation does not mean reaching agreement, nor does it mean the ability of staff, for example, to veto a proposal. You are still managing your business, and if change is what's required, then it's really a way of meeting these consultation obligations while still being able to implement what you need. Consultation is not an exercise in collaborative decision-making unless you wish it to be so. So again, you put your proposal out to staff and you ask them for their feedback, their commentary, pardon me, and their input. But all of that consultation does not necessarily mean that you're going to agree with them. So agreement might be an outcome of your consultative processes, but it is never presumed. And I think it's probably important that if you're going into any major consultative mechanism with your employees, that they understand these kinds of issues and these kinds of principles. Okay, so some of the benefits are, look, it really does lead to better decision-making with employee input. One, you avoid, resentment or, operating in a vacuum is never a good idea. People who don't know what's going on, not quite sure what direction the business is going in. So, if you give employees an opportunity to have a say, ultimately you may lead to, and employee input can also lead to your own better decision-making. it's easier for change implementation. So again, if you're introducing, new machinery, if you're introducing a new process or a new policy or something new that requires some significant change for employees, then if they understand what's happening, why you're doing it, and again, they have a say, then it will be easier to actually implement those changes. So you've got less time spent on responding to misunderstandings, to rumours or even disputes, which obviously will lead to better business performance. So we talk about improved employee engagement leading to better business performance. These are well understood principles in white collar industries across universities, etc., teaching institutions, nursing institutions, and it's a good time to start taking these types of principles forward in our industry. So we talk about making it real or keeping it real and making it count. So again, requirements to consult with employees around significant changes are set out in legislation, in awards and in enterprise agreements. And again, while the duty to consult does not necessarily carry with it the obligation to seek or reach agreement on the matter, it should, and in fact probably must, provide a genuine opportunity for workers to be heard about the matter before any decision is made. So the consultation needs to be authentic, regular, targeted and two-way. Now, if you're going to introduce major change which only affects a portion of your employees, those are the employees that you're going to be negotiating, or not negotiating, I beg your pardon. They're the employees that you'll be consulting with. So if you've got a whole heap of employees for which your proposal makes no difference or has no impact, there's no need to be going and consulting with those employees. It's really any employee who will be impacted by any proposal to change. So if we look at types of consultation, we can look at the more formal, constructions around consultative committees, and certainly people who've got enterprise agreements in place only until the 6th of December, you will inevitably have a clause in there that talks about a consultative committee. You can also have a formal work health and safety committee, and these are highly recommended. Certainly from a Fair Farms perspective, we see work health and safety committees involving staff, supervisors and managers as a really important element of your overall work health and safety implementation. You could do staff surveys once or twice a year. You can ask the difficult questions as long as you're prepared to hear the difficult answers. There was a saying that you never put out a questionnaire unless you know what you're going to get. They're not particularly valuable to have your own, beliefs confirmed. It's best to have genuine input. And of course, you can always have more formal staff meetings and even workshops. Induction is probably another point at which you would be talking about how you consult. More informally, you know how this happens pretty much on an everyday basis. Excuse me. Open door policy or a tap on the shoulder. Boss, what do I do about this? Some people have toolbox meetings once a week, once a fortnight, once a month, where they might pick one or two topics or, relate to something that's happened more recently that might need a reminder. Some do pre-start end of day briefings. They might be 5 minutes or 10 minutes, but we know some growers do that just to make sure, did anything go on during the during the day? Did anything come up? Is there anything to report? You could do it also during a rest pause or a lunchtime. I mean, you don't want to be taking up people's, lunchtime, I guess, for, training, but nonetheless, there's no reason why you can't have an informal conversation around a particular issue. Emails, newsletters, social media, if you've got an intranet system, so an internal web or email system. And as always, I say this ad nauseum, keep records. So if you are being audited, or if the Fair Work Ombudsman or the Work Health and Safety Inspector comes onto your property and wants to understand how you undertake your consultation, if you're able to point to a series of records, even if they're just informal meetings, we got together Friday afternoon for 10 minutes and we talked about ladder safety, or we talked about pre-checking the forklift, or we talked about knife safety. Make a note of it. It happened. Who was there? And then you have a really good record. And all of this is training in some way and will benefit you, should the proverbial hit the fan, as it were. More formally, when we look at the Horticulture Award, you need to consult with employees either individually or collectively around these matters. So Clause 5 covers individual flexibility arrangements, and as the name suggests, they're individual. Similarly, requests for flexibility, requests for flexible work arrangements, which is a slightly different, it comes in under the Act. Casual conversions, you have some obligations around offering long-term casual employees a conversion to full-time ongoing employment. But Clause 13, hours of work and the span and the number of hours per day, that's a collective issue. So if you want to change your span of hours or include your Saturday in your ordinary hours, then you need to do that collectively with those staff who will be affected by that change. Meal breaks and rest pauses, you generally would do that collectively simply because that makes no sense to have individuals wandering off at various times during the day. Major change, as we've said, that requires major consultation. And if you're considering changing rosters or hours of work, then you need to consult with those affected employees as well. So you can see that the Horticulture Award already requires, consultation around a range of issues. So it's wise to have a framework in place that can guide both you and your workers. A bit more detail around Clause 28, and I've actually just included the clause here. So it specifically says if an employer makes a definite decision to make a major change in production, program, organisation, structure or technology that are likely to have significant effects, they must give notice of the changes to those employees who are affected, discuss with those employees and their representatives, because this is where employees who are union members may say, well, this is a consideration, if this is a major change that's going to include termination, then we want to be talking with our union about it. So they need to be talking about the introduction of the changes, how they're going to be implemented, the likely effect on any employees. Is it going to lead to lost positions? Is it going to lead to having to move people around? Is it going to lead to increased training? All of those kinds of things. The effect on those employees is where those conversations have to focus. And any measures that you've considered to avoid or reduce the adverse effects. So again, is there potential for redeployment? Would people consider taking on part-time work for a period of time? There's a whole range of options that might be available, and you need to be able to demonstrate that you've at least thought about those options. And you need to commence discussions as soon as practical after you've made that definite decision. So once you've made a decision, you need to do it soon. Don't let it wait and fester. And the other thing about doing it as soon as possible is inevitably this is where rumours and misunderstandings will arise. So fairly important that we do that. And just a bit of a definition around significant effects. Again, this comes out of the Fair Work Act. So it includes termination of employment, major changes in the composition, operation or size of the employer's workforce, or in the skills needed. So, we don't actually need those skills anymore because we're, bringing in a machine or we're changing the jobs around, to rationalise a kind of reduction in workforce. Loss of or reduction in job or promotion opportunities. So again, if somebody, who's been there may have thought they were going to be moving to the top. Loss of or reduction in job tenure. So that's got to do with whether people who think they've got a long-term job no longer may have. Alteration of hours of work. The need for employees to be retrained or transferred. So again, this all comes into those conversations, and any job restructuring. So where you're changing the actual nature of the position. So, we actually want someone now who can do this, this and this, as well as that and that and that. So when you're beginning to think about introducing any effects that are going to have a significant effect on employees, then these are the clauses that you need to be reading and the processes you need to follow. Oh, I beg your pardon. Sorry, I do that all the time, don't I? Consultation around changes, again, in just a bit more detail. If you intend to change the regular rosters or ordinary hours, you've got to consult with those employees about the change first. So again, employ them with the information, invite them to give their views and consider those views before you make any kind of final decision. I'm repeating the process over. There's a method in my madness. I think if we hear it enough, we'll understand it. Okay, so consultation under Section 48 of the Work Health and Safety Act. Here they set out their nature of consultation, and this is what it requires. That relevant information about the matter is shared with workers. So whatever issue, new process, new policy, etc., that you're going to introduce around work health and safety, that workers be given a reasonable opportunity to express their views and to raise any work health and safety issues in relation to the matter, and to contribute to the decision-making process relating to the matter. So this is worded slightly differently, you know, where we talk about the concept of there's no opportunity for people to veto or to refuse a change, but the consultation under Section 48, because employees are meant to be, you know, fully engaged in work health and safety, sometimes those people are best placed to be advising on how to introduce new processes and etc. So there's a bit more emphasis on consulting with your employees around work health and safety. The views of the workers are taken into account by the person conducting the business or undertaking, so the employer, and that the workers consulted are actually advised of the outcome of that consultation in a timely manner. So if you have consulted with employees, you've taken their information and looked at it and gone, none of this is useful to me, then you need to advise the employees about that, which would require you to explain again why their input was not suitable or wouldn't work. So as I said, the consultation in this around work health and safety issues is a little bit more in depth. And certainly if workers are represented by a health and safety representative, which I'm going to talk about shortly, the consultation will always involve that representative or those representatives. Okay, so talking about health and safety reps, this came in from the 1st of February. All health and safety reps must undertake the relevant approved training course within 3 months of their election. So the primary role of a health and safety representative, a HSR, is to represent the health and safety interests of a work group and to raise any issues with their employer. So you might have more than one. You might have one in a packing shed, you might have one out in the field, you might have one in the office, you might have one in a machinery shed. There can be as many HSRs and deputy HSRs as needed after consultation, negotiation and agreement between the workers and the employer or the person, you know, the employer. The members of the work group actually elect their own HSR. So you don't come in over the top and go, this is the person I want. The people in that group for whom that HSR will be the representative, those are the people who actually elect that. And the employer must help to facilitate that election. That just means giving, you know, people an opportunity to do flyers and ballot boxes and things like that. So that needs to be done pretty much as a work activity. So their role and their tasks specifically include undertaking workplace inspections, reviewing the circumstances around workplace incidents, so any incident, near miss, accident, hazard that's been identified, accompany a Work Health and Safety Queensland or New South Wales or your state inspector during an inspection, represent the work group in health and safety matters, attend an interview about health and safety matters with a worker from the work group with the worker's consent. So if there is a particular issue about one worker and work health and safety, then the HSR can, with the worker's consent, accompany that person to a meeting. They can request that a health and safety committee be established and participate, obviously, in those committees. They monitor also compliance measures and investigate work health and safety complaints from their work group, and they inquire into any risk to the health and safety of workers in the work group. The other thing they can do is issue provisional improvement notices and direct a worker to cease, that is stop unsafe work, only where the HSR has completed the training. And you must provide and fund this training where the health and safety representative requests this training. And as we said, that's a formal training course. So they can issue a provisional improvement notice and they can stop work. And a provisional improvement notice means that they will tell you that there is an issue here that is posing a serious hazard or risk to health and safety, and therefore they have directed workers to stop until such time as that matter can be addressed. So they have some power in terms of, stopping work and issuing those pins when they feel it's necessary. Now, their training will cover all of that, and obviously they cannot be doing that willy-nilly. So the responsibilities of health and safety representatives are as much to the business as they are to the employees. Excuse me. Okay, so effectively, what we're asking you to do is to think about a communication strategy. And depending on the size and sophistication of your enterprise, this could be a simple document. And for my purposes, it's always useful to have a document that says, this is what we're doing and this is how we're going to do it. And this is how we're going to manage any problems. So a simple document setting out the ground rules for when and how staff communications will be handled and who will handle them. So don't forget to assign roles to people so that everybody knows who's who in the zoo. An internal communication strategy, as we said, outlines exactly how your business will deliver key messages. The what, the types of information that will be communicated. So, confidential, commercial you know what I'm trying to say, commercial and confidential issues. You're not going to be necessarily spraying that all over the place. So consider the types of information. Again, it's got to do with what impact is that going to have on your people. Who? So the messages need to come from somebody with the authority of senior managers. And then engaging with the reps, whether they're work health and safety reps or just staff nominated representatives from different parts of the organisation. Well, that will help ensure the communication is seen as having broad support by the management. That means if you are seen as open and transparent and you're inviting your workers in to hear what's going on and to have some input into that process, you will get more support for your proposal than if you had ignored, their wishes. How? Again, it's about messages being clear, consistent, and given with some context. So always include, this is why we are doing this, why we need to do this. Again, commercial in confidence is not necessary, but certainly, if, the market prices have been so poor, we're driven to do this, then those are the kinds of things that you can also communicate. When? Communication around major changes, particularly affecting staff, should be prompt and you should give employees time to respond. So there's no point saying to them at 5 o'clock on Friday or 5 o'clock on Thursday, we need a response by 9 a.m. on Monday or Tuesday or Friday morning. So be flexible, refine your strategy and make sure it remains effective. So, get something up there on paper. And again, keep records of those conversations. You may need to refer to them down the track, particularly if termination of employment is an issue. Okay, let's move on. The role of unions. So we know that unions are bodies that represent the interests of workers, in particular industries or occupations. So we know, for example, that the the AWU represents a whole range of occupations across a whole range of industries, including health, education, horticulture, agriculture generally, etc. Unions can work on behalf of individual employees and or in industries and occupations collectively. So that's a very important part of their role, as you would understand. Key roles can include assisting to resolve workplace issues by being a voice for employees. So again, taking on that advocacy and representative role, as well as acting as a bargaining representative or a bargaining agent during enterprise bargaining negotiations. Other responsibilities include ensuring that employers are meeting their minimum obligations and looking into any suspected breaches of workplace laws, i.e. breaches of the award, discrimination laws or work health and safety laws. Let's just talk a moment about the difference between a representative or an advocate as opposed to a support person. And a support person is often someone who accompanies an employee who may have to attend a disciplinary meeting. These roles are quite often confused. So it's really important that in any discussion where the likely outcome will be disciplinary action or termination of an employee, and they're entitled to have a support person with them, it's important that everybody in the room understands these roles because they're quite different in nature, and they can lead to some really serious outcomes, which I'll talk about briefly shortly. Okay, so the role of an advocate suggests a party with an active participation in the process. So that is someone who promotes the cause of the employee and who may challenge the reasoning or make inquiries of the employer about any decision that they may have made or are about to make. So the advocate takes on a clear representative role, and a person who may have been threatened with termination may call in a representative to represent their interests. That is not the same as where an employee is asked to attend a disciplinary hearing meeting and is invited to bring a support person with them. A support person is a function more like an observer to a process, somebody who can take notes. They are a silent witness. Their role is not to speak unless it's to assist the employee to understand a line of questioning. They may be a supportive influence simply by the fact of their presence, but they do not themselves participate in this process. And it's really important to understand the role of a support person as opposed to the role of a representative or an advocate. Oops, sorry. And this is because only the employee knows certain facts. So one basic rule of investigations is that only one person is interviewed at a time, and only the employee or the interviewee can and should ever give evidence regarding matters or incidents. That's the whole purpose of the interview. It's not to have somebody cut across and try and explain what happened. It is entirely up to that employee who is required to give evidence. So only the employee was there at the time of the incident or can provide information about the matter at hand, and that is why they're being interviewed. If a support person was also present during the incident being discussed, they are not an appropriate support person. They are a witness. And being a witness, they need to be interviewed separately, perhaps with their own support person. So you need to be mindful of not only the role of the support person, but also who that support person might be. You cannot identify anybody's support person for them. You can't nominate a support person. They need to nominate their own support person. And before, as I said, and before any discussion, it's absolutely vital to clarify the role of any because they might bring the union representative along to the meeting as a support person. So that's the first part of any discussion, is to clarify the role of the union representative in that meeting as a support person and to remind them of their role if they deviate it. However, you cannot unreasonably refuse an employee's request for a support person, as this may result in an unfair dismissal claim. Now, I raise this because there was a recent case where one employee who had been asked to come to a disciplinary meeting brought their union representative along, and that union representative actually refused to act as a support person. They continuously said they were the employee's representative and they would act as a representative. The employer cancelled the meeting, and this happened several times. And in the end, the employer came out to the last meeting and handed the employee a termination letter. That employee then claimed unfair dismissal because they were refused a right to have their support person present, and that employee won that unfair dismissal case. So you can see how tricky this is, which is why we often also suggest that if you find yourself facing this situation, you double check with your workplace relations person, whether that's us or whether that's through, some other provider, to make sure that the process that you're about to undertake is as crystal clear as you can make it. I find that case a bit disturbing simply because the union official refused to behave as the support person and really kind of pushed the employer to take an action that in the end they should not have taken. It cost them. So I just wanted to make sure that you understand that at the beginning of any meeting, this is the kind of conversation that you need to be having. Okay, let's talk about the right of entry. So union officials have a right to enter a workplace or business premises to investigate suspected contraventions of the Fair Work Act, your award or your enterprise agreement, or to hold discussions with employees to exercise their right of entry, and that's employees who want to meet with them. To exercise their right of entry, a union official must have a valid right of entry permit, and they must meet the entry requirements. State and territory work health and safety laws also provide rights to enter a workplace for union employees for work health and safety purposes, and there are another set of rules for getting the work health and safety entry permit and exercising this type of entry. So the first thing we understand is that they need to have a permit. So the permit looks like a driver's license. I'm sorry I couldn't find an image of it. I looked everywhere. But it's the size of a driver's license. It shows the permit's holder name and the organisation, so the union to which they belong. It should have a photograph and their signature. It will have a permit number and an expiry date. If there are any conditions applied to a permit, and sometimes there might be, those should also be on the permit. And then there will be a QR code where you can go and look up other permit holders. The bill also empowers the Fair Work Commission to impose conditions on a permit as an alternative to what they used to do, which was revoking or suspending a permit. So it may be that the permit does come with some form of conditional provisos, etc. So some of the reasons why a union official may want to enter a workplace, they might want to investigate if they suspect the employer has breached the Act or other instruments. So that's an enterprise agreement, perhaps a contract of employment, and there's some special provisions around textile and footwear industries. Meet with employees again. So if employees want to meet with the union, then they can meet they don't have to be members, and they can use their rights under work health and safety laws as well. They can enter the premises to investigate if they suspect the employer has breached the Work Health and Safety Act. And again, we talked about the additional work health and safety permit required. They can inspect documents that relate directly to a suspected breach or contravention, and they can consult and advise workers. They must provide a written entry notice to the site occupier, so to you, the employer, and any other affected employees at least 24 hours, but not more than 14 days in advance. The Commission can give permit holders an exemption certificate in some circumstances if it defeats the purpose, giving notice defeats the purpose, which allows them to enter without notice. And where they have done that, they need to then provide that entry notice as soon as possible after they've entered. Under the Work Health and Safety Act, they can inspect and make copies of relevant documents and consult and advise workers. In these cases, they again have to give written notice of no less than 24 hours and no more than 14 days. So this is the Work Health and Safety Permit. And again, this doesn't apply if giving notice would defeat the purpose of the entry. So that is, if something has been identified and then overnight the employer fixes it or changes it. So it may be that there's a call made and somebody rocks up literally, and don't turn them away, because if they're coming to inspect a particular complaint that was made and you refuse them entry, there could be some problems. So it's about not unreasonably delaying the visit so they can check out what's been said. So the rules are different if they want to investigate a suspected contravention of the Work Health and Safety Act, and they must give written notice, whether that's before or after. So whilst on the premises to investigate a suspected contravention, the union may do any of the following: inspect any work, process or object relevant to the suspected contravention. So that might include having a look at machinery. Interview any person about the suspected contravention who agrees to be interviewed and whose industrial interests the union is entitled to represent. So if you get a representative from, the National Tertiary Education Union, I can assure you they are not entitled to represent workers on your farm. So that will be demonstrated through their permit. They can require that certain copies of certain documents be made available to them. It allows the permit holder to inspect and again make copies of any record or document that is directly relevant to the suspected contravention and that you have on the premises, either, in hard copy or that is accessible from a computer. So they have a right to ask to view contracts of employment and pay slips and all of those kinds of things. And again, unwise to refuse to provide that information. Things just get a lot stickier from there. A Fair Work entry holder, while they're on your site, they have some obligations. They must always carry their original permit and a copy of the notice of entry or their exemption certificate. They must hold interviews or discussions in rooms or areas that the occupier agrees to. And if they don't agree, they might go where the workers would normally eat meals or take other breaks. Please don't, kind of give them a room or some reasonable space to have a meeting in. Again, we're going to be talking about conduct when the union calls, and any, kind of decision to allow them to only meet in the middle of the hot paddock would be met with some raised eyebrows at the very least. But you can that you can nonetheless get them to comply with reasonable requests to take a certain route. So you can keep them away from, dangerous areas and things like that. And yes, Kirsten, it's best if the managers are not in the room. Unless they're union members and they are entitled to be in the room, I would suggest that managers leave the room. If you've got a good consultative process with your employees, and you've got trust built with your employees, then your employees will come and talk to you about these issues, and those things will go smoothly. Where that relationship doesn't exist and where workers feel like they cannot speak with you, then these are situations in where you're more likely to have them calling that third party to come and represent their interests, and that third party is the union. They have to abide by the conditions of their permit, and they must comply with all reasonable work health and safety requests. So again, if there's certain pathways you want them to take, again, be reasonable about that. They are not to enter any part of the premises that is used for residential purposes, including yards, etc. And they can only visit a workplace during working hours, and any meetings they want to have can only be held during lunch breaks or rest periods. And bearing in mind, if you've got a 15-minute rest period, that's a very short break. But certainly if they wanted to do a 30-minute presentation, my best advice is to allow them to do it, provide them with some, space to do it, acknowledge that the workers have brought them in, and at some point you will be having a discussion about what's going on. No permit holder may intentionally hinder or obstruct any person or otherwise act in an improper manner. Give the impression that they are authorised to do things they are not, or be reckless about giving that impression. So this is, where a permit holder may be threatening some particular type of action and they may not actually, in fact, be authorised to do it. And they cannot use the information that they gather for any purpose other than the investigation or the inquiry that they're undertaking. Permit holders may not inspect documents about a person who is not a member of the union, or that do not substantially relate to the employment of a member. They can use a specific Fair Work Commission form to apply to inspect those documents, or they can obtain written consent from that employee. So they cannot inspect documents of workers who are not union members without their express permission, and that must be written. So within 5 days of entry, the permit holder can also then ask for access to other records and documents at a later time. So they may then come back and say, well, we're coming back out in 24 hours and we want to look at these documents. But they've got to give you, well, we're not coming out in 24 hours, are we? We're coming out in 14 days. So you have to have notice to give you an opportunity to prepare what information they're looking for. Again, it's a process. Like any other process, follow the process. So the conduct of the parties. So currently the legislation talks about a person not intentionally hindering or obstructing a permit holder. So on the other side, this is you guys. But this provision's now been amended to add an additional obligation on the person not to otherwise act in an inappropriate manner, and I'll talk about that shortly. There's a civil remedy provision, so the fines are very high, nearly $20,000 for an individual or $94,000 for body corporates if you are found guilty of hindering, obstructing or behaving in an otherwise inappropriate manner. These provisions apply, in relation to each permit held by the permit holder on or before after, issued before, on or after the 1st of July. Okay, inappropriate manner, behaving in an inappropriate manner. This extension is intended to cover a fairly wide range of conduct that intentionally hinders or obstructs a permit holder, that is a union. It could include, depending on the circumstances, swearing at a union person, please don't tell them to, off. Making offensive, racist, sexist or homophobic comments or acting in any kind of physically, verbally aggressive manner or an intimidatory manner towards permit holders. So again, this is really, let's mind our manners. This is a process. The more you try and stop it from happening, the worse it will become. So put our best behaviour caps on and manage it as a process. Step 1 is this, step 2 is this, step 3 is this. Okay, it is illegal under the Act for an employer to take adverse action against an employee because they sought union representation. They are well within their rights to talk to their union about any issue related to work that they want to, and you cannot take action against them simply because they use that workplace right. Adverse action might include dismissal, any form of discrimination, demotion, suspension, issuing of, unnecessary warnings or commencing disciplinary processes. In practice, it means that even if a fraction of the reason that the employer took the adverse action against the employee was because they wanted the union representation, that employer can be hit with a general protections claim. So it can go either way. An employee may take an unfair dismissal claim and state that they were refused a right to have their support person of choice, or they may just take it as a general protections claim to the Fair Work Commission. So there's a number of avenues that employees have if you take any kind of adverse action against an employee. So again, all your workers have a right to join a union. If you have a really good consultative process, you should be able to, keep the waters calm. If you have a combative attitude and approach, then you can expect that things may get sticky down the track. All right, so key takeaways. I'm sorry, I've kept you 10, 11 minutes over time. Again, set up a consultation framework with your workers, formal, informal, and use it. If you don't already do a toolbox meeting, at some point during the week, set one up, just a regular chat. Pick a topic, 10 minutes, and have a chat with your workers about it, and then make a record about it. Again, ensure your consultation is authentic, regular, targeted, and two-way. Include staff representatives from each section if relevant, and provide some training around these issues that we've just talked about, how we want our consultation to go. Elected work health and safety reps are entitled to be trained, and they have a specific set of tasks and duties which you must respect. And again, if they want to undertake that training, you must provide both the time off and you must fund that training. Get to know the rules around freedom of association, the rights for employees to belong to a union and the rights for them to use that union if they feel the need. Understand the right of entry, understand the permits, understand the notice, and understand your approach. So consider your approach with union engagement and prepare for it as much as you can. Don't overreact and don't try and stop employees from utilising their genuine workplace right. Again, it will just lead to tears. All right, that's the end of today's webinar, but I do want to just remind people, particularly anybody in the southern states, about our Fair and Ethical Sourcing Conference. We've got a whole range of fantastic industry experts, growers, workplace relations specialists, peak industry bodies, all coming together in one place to discuss ethical sourcing within Australian horticulture. So the theme for this year's conference is Perspectives and Solutions in Australian Horticulture. And we've got a whole heap of speakers and panels on these topics that we've just talked about. If you're not familiar with a lot of the social compliance stuff, it will serve as a great baseline for ways to identify how we as an industry, as well as how we as growers, can adapt and continue to support and celebrate Australian growers and our horticulture workers. And we really would like to acknowledge and thank our conference sponsors who support us in our Fair Farms endeavours. We just couldn't do it without AusVeg, without the Endeavour Group, without Ask Your Team, without Swaggy, AgriTalent, or Southern Cross. So thank you very much to those guys. We're really looking forward to networking with you. Just a little where we're going to be. We're at the Fair Farms National Conference, obviously, 20th of October at Cargo Hall. It's going to be great. We've got a gala dinner and our Fair Farmer of the Ward announcement. We'll be at the NFF National Conference in Canberra. We're hoping to be at the Citrus Australia forums all over the southern parts. We're at Wahoo, the Western Australia Horticulture Update. Keep an eye out for some Fair Farms workshops, and we may well be down in Victoria again towards the end of the year. Thank you so much for joining us again today. It's always great to present these webinars to you, and I hope that you find them useful. Let me just pop my nose into the chat box. I think I saw. Is there a size limit to the number of staff? No, there's not. Look, in truth, if you've got 10 staff and your staff or 5 staff and your staff want to elect a representative, it's a good idea to allow them to do that. There's no, and where you want to think about the number is actually where you get bigger rather than smaller. If you're small, you may just need one person, but if you've got large numbers of staff in distinct areas, you may it may be wise to have them elect their own representatives, and then you're bringing all of the information in from each of those areas. At induction, do we have to leave the room? No, sorry, no, not induction. It's where if the union wants to come onto your site, so where they've issued a notice of entry, where they come out in lunchtime and they're going to have 20 minutes with your workers, in the shed or in the lunchroom or whatever, that's where we're saying that managers really do need to leave the meeting. Those meetings are union meetings and they are generally closed to union members. So, and again, as I said, if you've got a good relationship with your workers, you'll kind of find out what's going on. What rights do employers have? You can make a complaint, Keith. You can certainly complain to the union, and you can probably go through the Fair Work Ombudsman and talk to them about it. So there are avenues for inappropriate behaviour, and I think the first approach would be letting the State Secretary of the relevant union know that the conduct was inappropriate, why you thought it was inappropriate, and then, kind of see what happens from there. There are certainly some ways to do it. Perhaps we can check that out and follow up with you. Okay, thank you very much. I have kept you 15 minutes longer than I intended to. Great to see you all. Have a great week, and we'll see you in a month's time for number 10. And again, my apologies, but topic to be announced. Thanks very much. Bye, everyone.